An ownership interest in a business is a type of property. Consequently, if one or both spouses have an ownership interest, then a court will need to characterize it as either community or separate property to determine what portion, if any, is divisible upon dissolution. A business started during marriage using community property funds is community property. Because of the community property presumption, a business is presumed to be community property if started during marriage. A spouse claiming otherwise will need to prove that the business was started with separate property funds. A community property business will be divided equally between spouses at dissolution. The assets to be divided include the business's goodwill. Goodwill refers to a positive perception by customers that provides a business with an economic advantage. A business started by one spouse before marriage is that spouse's separate property. But often, a separate property business will increase in value during marriage, raising a question as to what portion of the business's value is community versus separate property in a dissolution proceeding. The answer depends on whether the growth is primarily attributable to a spouse's work or market forces. Recall that a spouse's labor is a community asset, and the fruits of such labor are generally community property. Consequently, if the value of a separate property business increases during marriage because of either spouse's labor, the growth is community property.